Okay, welcome everybody. Today we're going to talk about civil rights. I think civil rights are kind of one of the most important things to talk about today, especially with the kind of issues that we're seeing. A lot of civil unrest that kind of harkens back to the civil rights era. Um, Now, obviously, much like the civil rights era, today is a very contentious time. Some people argue that there's no real need for the type of protests and response that are happening. Um, I don't think that that's accurate. I think certainly that there's certainly still things happening in the United States that warrant protest and that warrant people being upset and being angry. In fact, but we're going to talk about kind of the history of civil rights a little bit, and then I want to talk about some current issues that we see today. Okay. All right. So what is civil rights, or what are civil rights? So basically, civil rights are policies that are made to protect people against discrimination by the government, or oftentimes businesses that do business with the government. Okay. Generally, civil rights apply to what are known as, historically disadvantaged people. And I don't like that term. I don't really like the term historically disadvantaged people, because it doesn't really put any onus on the fact that there is racism and oppression in this country. It kind of makes the perpetrator ambiguous. Are people disadvantaged due to nature? How are they disadvantaged, right? Well, if you know the history of the United States, and if you're honest about the history of the United States, then much of that disadvantage looks more like oppression, right? It was purposeful. It was intended to keep people down, and to keep people as a kind of separate class of citizens. So what civil rights tries to fix are those historical oppressions, right? Tries to make up for them and to bring people, generally people of color, but other um, you know other minority groups, up to a level to where they can participate in society at the same level as the majority of white Americans. Okay. So racial discrimination, gender discrimination, and other kinds of discrimination are basically what we're looking at when we look at civil rights, right? Discrimination might be a little bit too light of a term, right? Discrimination is kind of what we think of today as perhaps one of the defining things that are happening of civil rights. But, oftentimes this was violence. This was murder. This was, you have like the Tulsa race massacre, where white Americans who were jealous of affluent African Americans in Tulsa dropped bombs and burnt their neighborhood to the ground, killing somewhere upwards of 500 people. Right? You have several incidents very similar to this that people really don't even know about. Right? It wasn't just discrimination; it was outright terrorism and violence. Sometimes, okay, especially when it comes to race, gender discrimination. Now, we can do a whole separate lesson on gender discrimination, because it's more complex when we talk about like wage discrimination and things like that. And I think that bears kind of getting deeper into, because some people have retorts that wage discrimination doesn't exist. In a certain way, if you look at the data a certain way, it doesn't. But if you look at the data in a more honest way, you can see that, for example, when women tend to move into a field, a job field, that field tends to drop. That the pay in that field tends to drop. So we can assume that something about women entering a job field, and I think that it's an independent of just more people in the job market. Okay. discrimination based on age, disability, sexual orientation, religion. So, I mean, these are all, all very important in and of themselves. But when, you could teach whole classes on each one of these things. And I don't want to say that they are less important, because they're obviously not. But the real kind of struggle, and the most prominent struggle in the United States, has been a struggle because it's been the most kind of violent and brutal. It has been the struggle for racial civil rights, or civil rights of Black Americans, but not just of Black Americans, of different minority groups as well. Okay. So 2 centuries of struggle. So, and this is something that I want everybody to bear in mind as we kind of go through this. When anybody, and it's one of the most frustrating things, right? If you ever hear somebody say that slavery ended 200 years ago or whatever, like, it's nonsensical in several ways, right? It's nonsensical because slavery itself was not the only form of racial oppression that happened in this country. Racial oppression still happens today, even if you choose to ignore it. But there's been a long history of racial oppression. And when slavery ended, racial oppression did not end, right? It maintained, and in some ways, the Jim Crow era South, for example, was more brutal than slavery, which is, I'm not trying to compare either one. They're both, horrific. But in terms of extrajudicial murder, terrorism against Black communities, the Jim Crow South was absolutely brutal. And the Jim Crow South existed within, the lifetime of some of your parents and some of your grandparents, right? So it is not, it's not something that is just 200 years ago. Also, it's just nonsensical in the fact that things that happened in the past affected things that happen today, right? Of course, things that happened 200 years ago will still have ramifications today, much like things that happened 2,000 years ago still have ramifications today, right? Christianity is the largest religion on the face of the earth because of something that happened 2,000 years ago, right? So it just doesn't make any sense to say that something happened in the past, therefore it doesn't affect today. Well, of course it does, right? Events of the past affect things in the future. That's how causality works. That's kind of our whole premise of causality. So don't say that. It's a bad argument, okay? And if you hear somebody say that, then call them out for it, because it doesn't hold water, okay? Okay, so now, when we look at equality, there are different ways of looking at it. We can look at equal opportunity or equal results. And a lot of people say, well, we want equal opportunity in this country. And I agree. I think that equal opportunity is good. It's kind of more let people want to rise and fall based on their own merits. But the question is, have we even ever achieved equal opportunity, right? I think we'll find that no, we haven't. Right, because to have equal opportunity, in some sense, you have to have an equal playing ground, and we don't have that yet. So the Constitution is. Let me go back. The Constitution is not a document that is overflowing with a lot of sentiment on equality. We know that the Declaration of Independence comes right out of the bat and talks about equality. The Constitution doesn't. A whole lot. I mean, it's implicit in there, right? Popular sovereignty, states, equality of a vote, but we don't, we have very racist things in our Constitution that don't actually address the issue of equality and actually further inequality. The first mention of equality is in the 14th Amendment, which comes about after the Civil War, or during the Civil War. This kind of the Civil War amendments to effectively give equal protection, to make or to codify the fact that Black Americans are equal citizens. So we have the 13th Amendment that ends slavery, the 14th Amendment that gives equal citizenship rights to Black Americans, though still not women, right? Because women aren't going to be able to vote for another 60 years or so. And then the 15th Amendment, which gives black men the right to vote, okay, or which codifies the right of black men to vote, okay. So one of the kind of all-time worst Supreme Court cases is a case called Dred Scott. So it's Dred Scott v. Sanford, and this is in 1857, right? This is before the Civil War. And what this case effectively says, it says that slaves are known as chattel, and chattel is property. Slaves have no rights. They are not citizens. This effectively invalidates the Missouri Compromise. So Congress doesn't have any authority to ban slavery in subsequent states that are kind of popping out west. So, this case is really kind of a dark stain on Supreme Court. Subsequently we have the Civil War, and out of the Civil War, you get the Civil War amendments. So those ones I just talked about, the 13th, 14th, and 15th Amendments. So they're ratified after the Union wins the Civil War, and they outlaw slavery, expand citizenship rights, and voting rights. Now, not to belabor Dred Scott, because it's a horrible decision, but it is part of our history. Scott moves from one state to another. He moves from a slave state to a free state. And they kind of dodge the whole question whether or not it's a matter of a free state or a slave state, and say that he's not a citizen at all, right? He can't be a citizen because he's black, right? So again, it's even deeper than like state v. state. It's like a question of like fundamental identity as a human being, and whether or not you have the rights to be a citizen in the United States. So again, one of the worst Supreme Court rulings. And there's some bad ones, but this one's really bad. The worst, or if not the worst, then very close to it. So following the Civil War, you have a Reconstruction period where you actually see a significant amount of promise for black people in America. You start seeing black men on legislatures around the country. And this is when the South is still firmly controlled by the North, right? We can get into the history of it. It's actually, really interesting to look at how this project failed. But basically, long and short of it is that the Union kind of moves out of the South, and things basically go back to this apartheid state. Jim Crow or segregation laws. Jim Crow is not just segregation. Jim Crow is segregation is awful, but it is, it's kind of I don't even want to say least offensive. It's just, if you talking about like segregation, but also racial terrorism, you're talking about murder, you're talking about, bombing of black churches, setting fire to black churches, rape and murder of black men and women, destruction of black communities, right? So this kind of Jim Crow South that we get via our American imagery is always just like, oh, it's kind of segregated, and black communities are a little bit poorer. It's like, no, it's much worse than that, right? It's not just that people use different water fountains, right? It's that, black Americans were fearful that they could be murdered, and many times were, for just being in the wrong place at the wrong time. Okay. But as it matters, as we kind of talk about this, we do have to talk about segregation, because a lot of the legislation and court rulings deal with segregation. Segregation is nefarious in a lot of ways. Segregation tends to negatively affect minority groups, right? Because not just because the facilities that minorities get are usually much lower, which is true, but also just because segregation is in effect, right? It's damaging to the psyche to be split apart, to be seen as less than, to be seen as inferior. Okay. So Plessy versus Ferguson. And again, I want you guys to think about the timing on all this. Plessy versus Ferguson. So we have Dred Scott case in 1857. Here we have nearly 40 years later, after the Civil War, after the 13th, 14th, 15th Amendments, right? And we're already seeing kind of backtracking. Like, we're not seeing progress here. Plessy versus Ferguson says that separate but equal accommodations are acceptable. So this effectively justifies racial segregation in the United States. Okay. Now, 40 years later, this is not progress. Okay. And you say, somebody in 1896 probably said the same thing. Well, slavery ended, 30 years ago. What are people complaining about? Well, the racial terror that's been imposed on people, the fact that the Black American psyche has been assaulted by not just slavery, but by racism. That the actual facilities are less, right? So let's see how long it takes to actually get some progress in this country. Plessy versus Ferguson. Well, let's talk about it just really quickly. Plessy versus Ferguson is a case where a man gets on a train or a rail car, and he refuses to move from a seat that's reserved for white people. Subsequently, he's arrested. In this case, moves up to the Supreme Court. The Supreme Court rules almost unanimously that segregation was constitutional as long as it had separate and equal facilities, right? Equal but separate accommodations, right? But those equal accommodations, one, are never equal, and as we'll learn in a subsequent case, they can't be equal, right? Because the very act of separating implies difference, right? Otherwise, there would be no need. Now, a lot of people include, and I'm almost reluctant to include, that Homer Plessy was only 1/8 Black. That even talking about race in terms of like percentages like that is kind of gross. It kind of harkens back to a like fraudulent race science of the time. So it's not really that important. I guess why people talk about it and why people say that is because their point is, well, he even looked white, which I don't even know what the purpose of saying that is, right? It doesn't really matter, right? He was discriminated against. He was viewed as a Black man, and this was, reason for his being segregated, or his being removed, or being told to be removed from this car. Okay. All right. So now, again, bear in mind, we now have made a jump, right? We've made a jump from 1896 to 1954. So we're nearly 60 years later. Okay. Now, again, keep in mind what I said about when people say, oh, slavery was 200 years ago. All right. Well, now we're in 1954. That's a 60-year jump from Plessy versus Ferguson, which is another 30-year jump from, or excuse me, another 40 years from Dred Scott. So we're talking about like 100 years right now, like 100 years before we move from black people in this country are chattel property to segregation being found unconstitutional. So in Brown versus, or at least in public facilities. So Brown versus Board of Education overturns Plessy versus Ferguson. And it says that school segregation is inherently unconstitutional because segregation itself is inherently unequal. And it's unequal because, like I said, it is based on a distinction, right? And if we assume that people of different races are actually different, then you'll be able to justify that, right? Segregation, it's based on a lie, and that lie is that there's a fundamental difference between races, okay? Something more than just a phenotypic expression of, some sort of, deep-seated genetic or, whatever reason to segregate people, okay? Cultural. I don't think they would say cultural, because cultural, they would want to basically argue that it's deeper than just culture. But they're wrong. So this is where we get the kind of distinction between de jure versus de facto. So de jure versus de facto discrimination, or de jure versus de facto segregation. So de jure segregation means by law. So by law, this is kind of the end. It's not probably, there's still probably legal ways of doing it by law. But just because something ends by law doesn't mean that it actually ends in practice. Okay, so de facto, right? De facto segregation is segregation that exists in reality. So discrimination not by law, but just by people being racist or people being discriminatory. Now, this is actually wrong down here. So, putting African American or putting black people in the back of the bus, that was actually de jure because that was done by the law, right? Separate but equal was done by the law, right? So that should actually be up under de jure. So just clarify that if you're taking notes. All right. So Brown versus Board of Education. This is a good Supreme Court ruling. The Supreme Court unanimously holds that the racial segregation in public schools violates the Equal Protection Clause of the 14th Amendment. Okay, so the 14th Amendment's really huge and really important, legally speaking. But never confuse law for morality. Okay, because the type of things, and people tend to do that a lot, but the type of things that were legal were still not good, right? The ruling in Dred Scott, right, or Plessy versus Ferguson, those are legal rulings, but they're not good rulings, right? They're bad. They're in some sense evil, right? But it's, at least we see some progress in Brown versus Board of Education. Now, with that said, we've talked about the Supreme Court, and the Supreme Court has no real enforcement mechanism. So do you think that the southern states all of a sudden just started, okay, well, we're going to jump on it. We're going to make sure that we're making these public schools very diverse now, and that we're no longer segregating our public schools? No, of course not, right? It takes the National Guard to forcibly integrate the public schools in some places. Okay, so the separate but equal doctrine is overturned, but we tend to hold on to things. The law is not all powerful. Okay, people's norms are oftentimes quite a bit more powerful than law. All right, so 10 years later, and this is what we're thinking, like, how is it possible that we're still needing to legislate this when we had a case 10 years ago that effectively said that segregation in public accommodations is illegal, right? Well, because it's still happening, right? So 10 years later, again, back to this whole thing, slavery is 200 years ago. Okay, well then why are we still having to litigate it, right? Why are they litigating it in 1964, right? Did racism just end when slavery ended? No, that's idiotic, right? So the Civil Rights Act of 1964 makes racial discrimination illegal in hotels, restaurants, and other public accommodations. It makes it to where employment discrimination based on race is forbidden, and creates the Equal Employment Opportunity Commission, and does some things to strengthen voting rights legislation. As you know, there were a lot of attempts to try to limit, and there still are today, to limit the access that Black people and other minorities have to vote. Okay. Now, just kind of talk about suffrage. Now, this is not a great picture for this slide because we're really not talking about women in this slide. But suffrage is the legal right to vote. The 15th Amendment extends that to Black men, but there are still attempts, right? There's still attempts following the Civil War to limit the extent to which African Americans can vote. So poll taxes are levied. White primaries. So poll taxes, right? That makes it doesn't make sense, but it makes sense why it would negatively affect Black people. Because if Black people are economically disadvantaged, then they're not going to have the money to pay poll taxes, right? Most poor people won't be able to, but that's going to dramatically affect poor Black people in this country, and Black people have higher levels of poverty than whites, right? So poll taxes are going to negatively affect Black people over whites. The white primary, only white people are allowed to vote in party primaries. Literacy tests. So these are really kind of interesting, and they're not even a real literacy test. They're like these. You can look them up. They're basically meant to get you to fail. But the only caveat to that is that they oftentimes didn't apply to white people because they were grandfathered in. And what that means is they had grandfather clauses. Well, if your grandfather could vote, then you don't have to take a literacy test. Well, whose grandfather couldn't vote? African Americans. Right? So they have to take these really Byzantine, difficult literacy tests. And I promise you, given the parameters that they put on it, I would be hard pressed to find anybody who could pass one, just because they're meant to kind of trip you up. And oftentimes they would have like one, you can only miss, if you miss one, then you fail. All right. And then give you like a really short amount of time to complete it. And it was just really kind of complex and difficult. Okay. Okay. So another way is that the states and different states try to keep people from voting, and the political parties themselves is through what are known as white primaries. And white primaries say that only white people were allowed to vote in primaries, because primaries technically aren't elections. They're not. I mean, they're run by the political parties themselves. We've had legislation following that, but that made them more of elections. But they were run by the parties themselves. So Smith versus Allwright ends white primaries. The 24th Amendment eliminates poll taxes for federal election. And then we have a case, Harper v. Virginia State Board of Elections, that ends all poll taxes. There's a second very important civil rights law called the Voting Rights Act of 1965 that basically makes it to where southern states are less able to discriminate based on race. some of those provisions have been undone recently. Because it's 2020 and nobody would want to discriminate in 2020, right? Because we're all so woke and we've all overcome all racism and all problems that exist in this country, right? Other minority groups, again, shouldn't take a back seat. We just have limited time, and the kind of predominant struggle in the United States. And I don't want to say this, I don't mean to downplay anything, but certainly like Native Americans have been treated, absolutely despicably in this country, as have, migrants from South and Central America, as have Asian Americans. But the course really focuses more heavily on the civil rights of African Americans. Native Americans obviously actually have had land taken from them, contracts that haven't been upheld by the U.S. government, have been put into reservations. Even those reservations have been shrunken, and they haven't had necessarily full autonomy. Hispanic Americans have faced significant discrimination, and kind of if Dred Scott's a bad case, the Korematsu versus United States case is really terrible as well. It holds that to protect against espionage, the United States, and this is still good law. I mean, when I say good, I don't mean it's a good thing. I mean, it's still this is still precedent. Like, nothing has overturned Korematsu. Held that you could basically hold people in detention facilities to protect against, and not just people, American citizens, right? Hold American citizens in detention facilities to protect against espionage. And this is obviously during World War II, when we're at war with Japan. So another horrible case that is actually technically still on the books. Okay, so let's talk about women for a bit, particularly women's right to vote. Again, we could talk so much more about discrimination against women in this country. We really could, and I think an interesting, or really, I don't want to say interesting because I don't want to downplay people's struggles, but a really kind of important discussion is also discrimination for women, just kind of in the workplace, but also assumptions about gender roles and who would be taking care of children, and things like that, and how that limits the opportunity of women. So the 19th Amendment extends suffrage to women in 1920, but from 1920 to 1960, we have this period called the doldrums. And this is where a bunch of very paternalistic laws are written to protect women. But ultimately, they protect men from competition from women in the workplace. These are type of laws that sound on their face like, oh, we're trying to, but it's kind of that paternalistic, like, oh, it's for your own good type stuff that we see during this period. Preserve, motherhood, the place of the woman at home, stuff like that. The Equal Rights Amendment has been put in front of Congress several times, and it's failed each time. So we see in Reed versus Reed that arbitrary gender discrimination violates the 14th Amendment's Equal Protection Clause. The Equal Protection or the Equal Rights Amendment failed just by 3 states in 1982. But we do see in Reed versus Reed, and that arbitrary is really important because there is still some levels of discrimination allowed, right? We do segregate, like, for example, like men and women's bathrooms, locker rooms, right? We do allow for some levels of segregation, but arbitrary gender discrimination in Reed versus Reed is found to be unconstitutional. Okay, let's get my head out of the way. So, the Civil Rights Act of 1964 bans gender discrimination in employment, but it still exists, right? It's just because the law exists, it's hard to prove gender discrimination, right? The Supreme Court has not actually ruled on wage discrimination and comparable worth. Again, some people argue, well, when you look at equal positions rather than just men versus women, when you look at equal positions, the wage discrimination goes away. That would be true if it weren't the case that women are almost across the board employed in areas that pay less. And it's not as if women want to be paid less. Like, oh, I just love to be paid less, right? So there are questions about, say, why the field of teaching pays less than other fields, right? Like female-dominated workplaces tend to pay significantly less than ones that are controlled by men. All right, women in the military. So this is kind of an issue that men face. Only men can be drafted. Now women can actually serve in ground combat. But the question about the draft is still kind of an important one, though we haven't had a draft, so it's not a active issue, right? It would only be an issue, and it could only be challenged if somebody brought it up, right? And that would require us to have a draft. Sexual harassment. So Title IX that's Title VII, but also Title IX. Sexual harassment is something that is often kind of brought up in the context of the university or in the workplace, right? And it's prohibited, right? Sexual harassment at school or at work is prohibited by the Civil Rights Act. Old people, I don't think it's a pejorative, but old, elderly might be a more delicate term to use. The rights of the elderly and people with disabilities. So, people in the United States we have an aging population. The Americans with Disabilities Act of 1990s requires employers and public facilities to make reasonable accommodations for those with disabilities, and prohibits employment discrimination based on disabled. Now, with that said, if your disability makes it to where you cannot physically do the job, then there's not much to be said there. Also, age. With age comes certain things that are not beneficial, right? Strength, for example, decreases with age. Some mental facilities or faculties can decrease with age. So there is room, and I don't mean this in a way to say like, oh, discrimination is good, but it doesn't mean that all discrimination is not allowed. Some discrimination is not allowed, right? When I was in college, I worked at UPS, and I loaded trucks, and I loaded, what are we call heavies, big heavy boxes full of bolts and, just real heavy stuff. And you have to lift it up and, put it in this bay and then load it into a truck. Well, if you're, 95 years old, you're probably not going to be able to get that job loading trucks at UPS, right? Why? Because you don't have the physical strength to do so. Likewise, if you have a severe disability that would make it, impossible for you to be able to do that. Okay, so that's why they put reasonable accommodations on these. Okay, so very important. Now, this slide is not up to date, but civil rights and gay and lesbian rights, another kind of really important thing. Two kind of landmark cases in 1986 and 2003, Bowers v. Hardwick and Lawrence v. Texas. So Lawrence v. Texas overturns Bowers, which says that homosexual acts can be banned or can be basically legislated against. Lawrence v. Texas overturns Bowers and says that private homosexual acts are protected by the Constitution. Gay marriage it has actually become it's all across the United States is legal based on a case called Obergefell v. Hodges, which is not actually included in this. So same-sex marriage is legal in the United States today. Okay, so affirmative action, this is a really kind of, people get, it's a very tough issue. Affirmative action is designed to give some sort of benefit to those who have historically been disadvantaged. And this is why I don't like to use that term disadvantaged. It's like, oh, I was walking down the street. Oh, no, I was disadvantaged. Like a tree fell on me, right? It's like not how racial oppression works. It wasn't that you just happen to be disadvantaged. It's like a systematic, sometimes conscious attempt at limiting the power and influence of certain people, right? But affirmative action tries to basically say that certain groups are underrepresented in things like, certain jobs and certain places like higher education. So in education, that's really important because education is really highly correlated with attainment of money, right? Of income and wealth. Okay, so this is where we see a lot of adjudication is around education. So two cases, Regents of University of California v. Bakke and Grutter v. Bollinger. So in Regents versus Bakke, the Supreme Court said that you can't set a quota for particular groups, but race could be considered for admission as long as it's not the sole criteria. Okay, so you can say, well, we're going to give people some benefit based on their race. In Grutter v. Bollinger, this is 2003, race could be considered a plus of a general factor for admission to university admission, but it cannot apply kind of certain astronomical point values to a certain race, right? So all, people of Hispanic descent get 95 points on a 100-point scale, right? They can't do that. Now, we've seen some really, kind of pretty big attacks on affirmative action. Fisher v. Texas. Texas had to use what's known as strict scrutiny, which is a high standard to show that that race is needed for admissions. Now, in employment, affirmative action, two cases, United Steelworkers v. Weber and Adirond Construction versus Pena. So 1979, United Steelworkers v. Weber says that quotas to remedy past discrimination are constitutional. And then in 1995, in Adirond Construction v. Pena, they say to be constitutional, affirmative action must be narrowly tailored and meet a compelling government interest. And narrowly tailored mean it shouldn't exceed beyond the case at hand, and it also has to provide some sort of compelling governmental interest, which could be ending discrimination. This didn't end affirmative action, but it severely kind of limits its reach, right? Race cannot be it can't be the deciding factor, basically. Okay. All right, so let's wrap this up and talk about something that's really happening recently and is still affecting us today. And that's redlining and residential segregation. So actually, the United States is more segregated today than it was in the late 1970s. Redlining is one of the reasons for this. Redlining was a practice of coding city maps according to the ability of the residents in that area to receive bank loans for home mortgages or home purchases. What does that mean? Well, effectively, it means that black neighborhoods were redlined or given a D ranking such that those who lived there couldn't ever buy homes because they couldn't get home loans. Right? Conversely, white people were moving to suburbs in droves away from the cities. Right? This is known as white flight. So they're moving. And this is prompted largely, in fact, by the fact that they can go out to the suburbs and they can get these loans that promoted the expansion of the suburbs and gave them low cost, easily accessible loans, right? So whereas black people are living in communities in the inner city, can't get loans because they're living in black areas. White people moving out to the suburbs are getting very low cost, easily accessible loans, right? And the fact of the matter is that Americans tend to hold most of their wealth in their homes. Okay, and we pass that on generationally, or you sell the home and then you have all that money when you retire, right? So it's really, it's a huge kind of boost to whites. Now, here's a map. This is the city that I am from, Fort Worth, and you can see the red areas, and you can map this on to Fort Worth today and kind of look and see, wow, some of these red areas are still very impoverished, right? The best is the green areas, slightly below that. Still desirable are the blue areas, red areas, or excuse me, yellow areas are declining, and then the black areas largely are the red areas, and those are considered, quote, hazardous loans, right? So you effectively can't get a loan there. Okay. How does this affect things? Well, it systematically ensures that black people don't build wealth, right? It makes sure that they can't build wealth like white people can in this country. And they can't transfer that wealth to the next generation as well. But it's more nefarious than that because redlining also affects things like even as basic as nutrition, right? Because as white people start moving out into the suburbs, these big supermarkets build up. Supermarkets put these small mom and pop grocers out of business, and those mom and pop grocers are the ones that are small enough to fit in the inner city, right? Those go out of business, and now these areas that are largely inhabited by black people don't have the same resources that white areas have. They don't have food, right? They don't have good, healthy food, groceries that are, actually good for you. You get fast food in corner stores that sell chips and soda and stuff like that. So you can see the way that urbanization or suburbanization actually has negative effects on health and well-being of black Americans. Okay, and this is still, redlining is illegal, but it still happens just because people employ their prejudices. Okay, when realtors, look for houses for people and kind of help them move into a neighborhood. Also, black home buyers are denied mortgages more than twice as often as whites, and blacks and Hispanics routinely pay higher mortgage rates than whites do, right? So this makes it much more difficult. Okay, so I hope this gave you a view. I mean, we could still talk. We didn't talk about police brutality. I think that police brutality is something that is, hugely important. Just to sum it up, Black and Hispanic and basically all minority groups face are more likely to face police brutality, more likely to die at the hands of police officers. Now, some Now, but it's a little more complicated because they're also more likely to have encounters, right? But this could very much just be a product of discrimination itself, right? Why are they more likely to have encounters? We know that drug use among whites and blacks is virtually identical, probably actually a little bit higher among whites. So that's a whole nother, can of worms, and it's not unimportant. It's actually one of the most important topics that's being discussed right now, and that's happening in this country. But unfortunately, we're getting close to the end of how long this lecture should be. So I'm going to wrap it up right there. But I hope this was informative, and thanks.